Thank you for joining us for today's briefing about erasing the Black vote in the Deep South and 5 voting rights activists fight back. On April 29, the Supreme Court struck down Louisiana's congressional map with 2 majority Black districts in a ruling that voting rights advocates say effectively guts Section 2 of the Voting Rights Act, the provision that prohibits voting procedures that dilute minority representation. Within hours, state legislators across the South called for emergency redistricting sessions in what many advocates see as the latest in a decades-long effort to weaken Black political power and representation. Our speakers today from Louisiana, Alabama, North Carolina, Mississippi, and the South in general will discuss the impact not only on Black voters, but on all voters, as well as the strategies being used to fight back. Let me briefly introduce our panelists. Mitchell Brown, Senior Counsel in the Voting Rights Section at the Southern Coalition for Social Justice and Coordinator of the Southern Leadership for Voter Engagement Network, or SOLVE. Amir Badat, Voting Rights Attorney and Political Strategist at Fair Fight Action. Devante Lewis, Louisiana Public Service Commissioner. Jerome Dees, Policy Director at the Southern Poverty Law Center, and Rian Wagner, Policy Narrative and Coalition Partnerships Director at Alabama Values.
Thanks for having me today again, Mitchell Brown from the Southern Coalition for Social Justice. And just to set the scene for today, the Callais decision, it came down a couple of weeks ago, really makes it hard for attorneys like myself and advocates on the democracy front. It makes it harder to challenge maps, and it makes it harder for voters of color to let their voices be heard in our communities. I want to start off by saying this is not new, though. This has been the party line, and pun intended, for a very long time, where when there are periods of increased voter participation, increased opportunity for voters of color, there's this white retrenchment that seeks to take it away. It took us decades to get voting rights and other civil rights, and it's now taken decades to try to dismantle it. And so what the Callais case does is it essentially makes it very hard to prove a Section 2 case, because now we have to prove intentional discrimination. What that means is that you have to have smoking gun evidence, essentially, of a legislator or legislative body saying, I drew this map to disenfranchise and to discriminate against Black, Brown, AAPI voters. And these legislators and legislative bodies are very cunning people, and they're not going to say the quiet part out loud. But maybe sometimes they will. And that's where we have to be prepared. And I'll mention the case where that actually happened in a minute. But, we have to now prove intentional discrimination. That's an issue because in 1982, the United States Congress amended the Voting Rights Act of 1965 and explicitly wrote into the amendment that plaintiffs would no longer have to prove intentional discrimination in order to prove a Section 2 case. And, now 44 years later, this court has now reversed track and basically taken away the power of Congress to enforce the 15th Amendment, which is Section 2 of the Voting Rights Act. And so it makes it very hard. And for all intents and purposes, this is an intentional discrimination case that we have to bring. And so what that looks like, and Pilar said at the beginning, is that now states are rushing to pass new maps. They are rushing to change Voting Rights Act districts that were drawn to comply with the Voting Rights Act. And some states are even changing districts that weren't drawn because of the Voting Rights Act, but are seeking to do so for partisan reasons. That's an issue because in the past, when we had the full Section 2, when we had Section 5, when we had, robust racial gerrymandering laws, we had a wide array of tools to use to fight back against redistricting, and now we don't have those anymore. And so, this rush to redraw maps is really problematic because now partisanship is taking the day rather than racial justice. And that's an issue. Um, One state that I'm going to call out because I think it really exemplifies the tension between race and party is Alabama. So Alabama in 2023 in a case called was Allen versus Milligan. Now it's Merrill versus Milligan. In that case, the United States Supreme Court said that Alabama had to draw a second minority opportunity district, and the state of Alabama said we're not going to do that. We're going to continue to draw maps that don't give a second district for Black voters. And a three-judge panel at the district court found that in doing so, they intentionally discriminated against Black voters in Alabama. Well, just this week, the Supreme Court reversed that essentially and said that Alabama can redraw its maps, completely disregarding the intentional discrimination finding at the lower court. And that's very, very problematic. And that's going to cause a lot of issues because now what we are seeing is Alabama gets a clean slate essentially to although they discriminated and were found to have discriminated against Black voters, they get to redraw a new map. What we're afraid of is that this is going to make it down to the local level. We're concerned that what's happening at the congressional level, what's happening at the state level, is going to find its way to local elections, and that's why we've been telling people to pay attention to the moves that are being made on a local level. There could be changes in changing nonpartisan races to partisan races, which would allow there to be some movement in districts and some gamesmanship in districts. And so we're telling people to be aware of that. But we're also telling people to also be proactive about potentially seeing if is an appetite for changing the way that elected officials are elected in your county or your jurisdiction. More of a proportional representation type of model to counteract this partisan gerrymandering that we're seeing. And so, Calais has right now federal level issues, but it may make its way to the local level. And we're trying to make sure that, racial justice still takes the day. Despite there being partisanship. Partisanship should never be the answer, especially when it impacts voters of color. And I think I have some time for questions now.
Okay, Carlos Roa, do you want to ask your question, please, and identify your news organization?
Thank you, Pilar. My name is Carlos Roa, and I'm representing Telecuento News, a digital news outlet in Spanish. My question for Mr. Brown is, since several southern states reportedly began discussing new maps almost immediately after the ruling, what specific redistricting efforts are you most concerned about right now?
So I'm concerned about all of them. But I'm mainly concerned about states that like Tennessee that just passed a map last week, eliminating, the only majority Black congressional district in Tennessee that, in our opinion, was not drawn based on the VRA, and was redrawn out simply to eliminate the Democrat that was in that seat. So I'm concerned about cases like that because they are misinterpreting the Callais ruling as you can't have Section 2 districts. That is not what Callais says. And so if other states are now going to do the same thing and redraw maps based on this theory that Section 2 is unconstitutional, that is a incorrect reading of the law.
Another question from Araceli Martinez, writing for Excelsior, I believe. Araceli, please go ahead.
I would like to ask what could be the implications or the impact for California, particularly for Latino representation, maybe not now, but in the near future. I would like you to know, what do you think about it? Thank you.
Yeah. So I mean, the short answer is it depends what the legislature, what the Redistricting Commission wants to do in California. I'm not as well versed on the Redistricting Commission in California. Maybe one of the other panelists are, but they have a choice to make. They don't have to draw out Latino districts, or draw out Latino voters or Black voters. They can make choices, to not partisan gerrymander. Like that is a choice that they have. So I'm not sure what the impact will be, and whether or not they want to protect Latino voters in particular. That's a choice that they'll have to make.
Well, California legislators don't write them, don't draw them up. So we have a special commission. But okay, Pamela has a good question. How does this ruling affect all other states in the nation? Well, it is the Supreme Court, so it affects the whole nation, right?
Yes, correct. Like this, Section 2 now is now not able to really fully be used in other states. One example that I'll draw out is Native American voters in Nebraska, North Dakota, South Dakota, like kind of the middle of the country. Section 2 has been a huge a tool for organizations like the Native American Rights Foundation, or Native American Rights Fund, excuse me, to challenge maps that harm Native American voters. So it will have an effect. And what I fear is going to happen is that what's happening now is there's going to be this partisan gerrymandering on both sides that is going to leave us as the voters in the middle.
And before we move on to the next panelist, can you briefly explain Section 2 for those of us who may not know? What does it do?
Yeah. So Section 2 had two portions. One is a vote denial portion, and the other one is vote dilution. And there's a case, I believe in 2020, Brnovich, that dealt with vote denial. So basically, laws and policies, that denied people the right to vote. That was at issue under Section 2 in Brnovich. Callais deals with vote dilution. So basically the drawing of maps and whether or not these maps have the effect of diluting voters of color's voices in the election. So it's not denying them the right to vote. They still can vote. Is whether or not their voice carries as much power and weight as other voters in their communities. So that's what vote dilution Section 2 was about. And, Congress allowed us to challenge maps that had the effect of diluting those votes. And now that's harder to do now.
Yeah, I remember covering this in LA County many years ago, the lawsuit to redistrict LA County. And one of the ways in which they dilute is they divide communities, right? So if there's a Black community that lives in a certain area, they will put a district here and another here. So they divide.
Correct.
They divide that community, right? So that's an example. Okay. So everyone understands exactly what we're talking about. Okay. Thank you, Mitchell. We're going to go to Amir Badat from Fair Fight Action, who will tell us what these decisions mean in the broader context of electoral power and representation. Amir, please go ahead.
Thanks so much, Pilar, and thank you everyone for joining. I am going to give everyone a little bit of context around Section 2. Mitchell described kind of what Section 2 does, but I also want to talk about it in the context of kind of the history of the struggle in America for civil rights and for Black political power. And that history has been characterized by advances in Black political power through struggle, blood, sweat, tears, war, like the Civil War, which resulted in the enactment of the 13th and 14th and 15th Amendments to the Constitution, which enshrined the rights of Black people and all citizens across the country. And that progress has historically been met with white supremacist backlash to quell that progress. And that's what we saw in the aftermath of Reconstruction. After the Civil War, we had the Reconstruction Amendments passed. We saw dramatic expansion of Black political power, Black elected officials across the South at every level of government, Black individuals voting at extremely high rates, and just a kind of historic Black expansion of Black political power. And what that was met with was violence, terrorism, and eventually the codification of laws that were framed as race neutral. So they didn't specifically say that they were trying to disenfranchise Black people, but they were intended to disenfranchise Black people in effect, like poll taxes and literacy tests grandfather clauses, and those were ultimately codified in the context of Jim Crow laws that started with, the 1890 Mississippi Constitution, which was then adopted across the South, or provisions from that were adopted across the South, and that was really the ushering in of Jim Crow. And so then comes, the civil rights struggle in the 1950s and 1960s, which resulted in the enactment of the Voting Rights Act of 1965, which included Section 2, along with a number of other provisions. And the immediate result of the enactment of the Voting Rights Act was, again, a dramatic expansion of Black political power. You saw voter registration rates among Black communities in the South go from the single digits to 50, 60, 70%. You saw the election of Black elected officials across local, state, and federal government. 4 members of Congress were Black in 1964. In just 10 years, that number more than quadrupled. And today it's in the 60s. There are more than 60 Black elected officials in Congress, and that is a direct result of the Voting Rights Act, and in particular of Section 2, which promised equal access, equal opportunity for minority voters to the political process. And that is the protection that the Supreme Court took aim at in the Louisiana versus Callais decision. And let's be clear that, this attack on voting rights didn't start with Louisiana versus Callais. As Mitchell mentioned, this has been in the works and in some ways is kind of the culmination of the attacks that we've seen against the Voting Rights Act, which started in 2013 with the Shelby County case, which eviscerated Section 5 and eliminated the preclearance requirement that Southern states were under. Then Mitchell mentioned Brnovich, which took out another leg of the Voting Rights Act, of Section 2 in terms of vote denial claims, our ability to challenge voter suppression laws that limit access to early voting and absentee voting and limit voter registration, things like that. And now we've seen kind of this last ditch effort, this last attempt to eviscerate one of the most important protections of the Voting Rights Act, and really one of the most impactful pieces of legislation that Congress has ever passed in our country's history. And so that is the context in which we are currently seeing all of these attacks on Black political power and the rush of Southern states to run as quickly as they can through the door that was opened by the Supreme Court to discriminate against Black voters in the South. We've seen in Tennessee, in Alabama, in Louisiana, in South Carolina, in Florida, and now most recently in Georgia, attempts to redistrict congressional lines as quickly as possible in an effort to change the makeup of Congress. And what we are going to see in the very near term, I think, is also an effort to change the lines at every other level of government. So Section 2 not only impacts the congressional lines, which Fair Fight Action and Black Voters Matter Fund published a report showing that up to 19 congressional districts are at risk of being redistricted, and some of them already have, like the Tennessee district rooted in Memphis. But Section 2 also protects districting at the state level, and so that's state legislative districts. We also issued a follow-up report that showed that up to 191 districts across 10 southern states could be redrawn without the protections of Section 2. That's almost 130 Black majority districts, which is more than half of the Black majority districts in those 10 states. And Section 2 also protects the districts at the local level. So think about your city councils, your school boards, your county boards of supervisors and boards of elections, all of those local governmental bodies that often make decisions that have the most impact on someone's day-to-day life. Those will now all be at risk of being redrawn because we no longer have the protections of Section 2. And these are not just abstract numbers. These have real political consequences and policy consequences on people's day-to-day lives. So think about the types of decisions that your school board makes. They make decisions with respect to funding of schools. They make decisions with respect to school disciplinary policies. They make decisions with respect to the types of curriculum that your kids are learning in school. And if you lose representation for Black people and voters of color on that type of governmental body, that results in real policy consequences. That means that there might no longer be someone on that school board who wants to reduce disparities in school discipline between white and Black students. There might no longer be someone on that school board who wants to make sure that we're not banning books about Black history in this country. And so those are real. Those are real tangible outcomes that will impact people's day-to-day lives. And so I wanted to kind of paint that picture for folks so that people really understand what the consequences of the Callais decision can be. And while we have seen this rush across the South to redistrict congressional seats, we are going to see soon on the heels of this rush efforts to redistrict state legislative seats. We've already heard the governor of Mississippi, Tate Reeves, say that in the 2027 legislative session, he wants to redistrict Congress, state Supreme Court, and state legislature. And we will see that happen, I think, across the South and potentially in other states as well. This is not just a Southern issue, although it will have a disproportionate impact in the South. This is an issue across all states, all communities, because we had the protections, like Mitchell mentioned, of Section 2 across the entire country, protecting districts that serve Hispanic communities, protecting districts that serve Native American communities. And so we're going to see the impacts of this across the board. I'll pause there. I'm happy to take any questions or hand it off to the next speaker.
Even though Mitchell made some comments to Alvin's question, I want to ask the question. Alvin Galloway, can you please ask your question out loud?
My question was, how can Black voters or Black citizens and other persons of color overcome this ruling? Because it will have a devastating effect on, like the speaker just mentioned, on people's lives and everything. And also, since this ruling, has there been a new energy from voters of color in trying to take action, positive action to overcome this in your areas?
Absolutely. I'll take a stab at both questions. So the first answer is exactly what Mitchell mentioned in the chat, which is go vote. Even though these maps, if they pass, will be unfair maps that dilute voting power of Black communities, it is still incredibly important for everyone to go out and vote in the upcoming elections and in every election after that, because in order to dilute, in order to draw more districts in which Black voters have less opportunity to elect their candidates of choice, these districts, some of these districts may become slightly more competitive. The existing districts that are already gerrymandered have to become slightly more competitive. And so there's an opportunity in some places, like in Tennessee, where we might not historically think that there's an opportunity for communities of color to elect their candidates of choice. There might be that opportunity. And so it's really important for everyone to go out and vote. I think even beyond voting, and this gets to the second part of your question, I think that there is a huge amount of energy and momentum that we are seeing swelling across the South. If you look at some of the videos and photos and content that's coming out of these special sessions, out of Louisiana, out of Tennessee, out of Alabama, what you are seeing is mass mobilization, organizing, the results of years and years of organizing by communities on the ground. And you're seeing people come out in droves. For example, in Louisiana, just this week, the state Senate committee that's considering their new map held a committee hearing on one of those new maps. They didn't start the committee hearing until 7 p.m. They waited until 7 p.m. because they wanted to wait out as many of the community members that showed up to testify at that hearing. But the community members stayed, and they, and Devante will talk more about this, they stayed until 4 o'clock in the morning testifying about why they did not want to see discriminatory maps introduced. That is just one example of the incredible mobilization that we have seen across the South. And to the question of what people can do, they can plug into these actions, these mobilizations, these demands on currently elected officials not to pass discriminatory maps and discriminate against Black people. And we're going to see many more examples of this over the next several weeks, months, and years. Tomorrow, there is a mass mobilization, national mobilization taking place in Montgomery, where you're going to have buses coming from all over the country and all over the South to make people's voices heard. There are going to be thousands of people rallying there. There's going to be a mass mobilization in Mississippi on May 20th, where Mississippians and people and allies are going to be marching from the old Capitol to the new Capitol, demanding protections for Black voting rights. And so these are all opportunities for people to plug in and to make their voices heard throughout this process.
And so we'll go to Jerome I'm sorry, to Devante Lewis. He's the Louisiana Public Services Commissioner, who will share his state's perspective and what communities there are experiencing on the ground. Mr. Lewis, welcome.
What we've seen in Amir really hit where we were coming from is the fact of what we've been experiencing. Over the last week, we have seen our Republican majority move rapidly to redistrict our state. We just this week had a hearing that, as Amir said, that lasted till 4:50 in the morning to redistrict. And what we saw is that they're moving rapidly fast because we had an election. When Callais came down on Wednesday, two Wednesdays ago, early voting for our congressional elections were supposed to start that Saturday. 42,000 Louisianians had already cast their ballots via mail and absentee. And the governor of our state suspended the election utilizing executive powers. And I want to be very clear about this executive power. Louisiana, we're bound to natural disasters and hurricanes. So our election code has a provision that allows that the Secretary of State or a clerk of court at the local level physically cannot perform the election, or the integrity of the election would be in question, that the governor can issue an executive order to suspend the election. Well, what our governor did, this is a policy used for natural disasters. He signed an executive order saying that the Callais decision is a direct violation of the integrity of the election, and therefore we can no longer have these elections. So while people are going to the polls tomorrow, their United States House of Representatives candidates are still on the ballot. The governor said those votes will not count, that he's going to throw those votes out. And just on Wednesday afternoon, the legislature snuck in an amendment on a pre-filed bill to now say that those ballots will not even be publicly disclosed, and that the Secretary of State can keep them hidden. So we are facing multiple fronts here on Louisiana, one with the suspended election that's due to take place tomorrow. We're now in a serious redistricting battle where yesterday the state Senate passed a new map that would reduce Black representation from 2 congressional districts down to 1 congressional district, packing Black voters all the way from Baton Rouge to New Orleans. And then one of the most rarest things that they have ever done, typically when we have a piece of legislation that is about redistricting, it contains voter information, registered voters, voting age population by party. Well, what the Republican majority did is they deleted voting population by race. So as of now, we can't even say what the racial makeup of our now new 6 congressional districts, if this map passes, because they directed staff not to even include that information in the analysis that has always been included in the redistricting analysis for the last 50 years in Louisiana. And so now we're off to the House side where we will see when they decide to take up this map. But here in Louisiana, it is a battle. And we are watching this happen. And this is on the lines of already watching our state governor and legislature target Black power. Earlier this year, the city of New Orleans elected Calvin Duncan with 68% of the vote to be the clerk of criminal court. He was a formerly incarcerated individual who was exonerated after spending 20 years in Angola, our state penitentiary. And he decided to run for criminal clerk of court because he remembered how hard it was to get his criminal records to fight his case. And he wanted to help people. Our attorney general and our legislature decided they didn't want him in that position. So just 2 days before he was due to take the oath of office, they passed a bill to eliminate his elected position and terminate the role because they said, well, we needed to do this for efficiency. So when we talk about now and this was pre-Callais. So now that Callais is here, we know it's going to be an onslaught of other elected officials that they will target and eliminate their positions. They also have eliminated now 4 judgeships in Louisiana, primarily Black judges. Louisiana has the highest share of elected Black judges in the country. All of our judges are elected. And they came specifically into Orleans to eliminate 4 judges. And this was also pre-Callais. And the irony is the author of our now congressional map that would reduce our congressional representation, the man who authored the bill to eliminate Calvin Duncan, and the person to eliminate these Black judges is the same state senator, Jay Morris. So one man has taken an onslaught on Black political power here in Louisiana, and we know that it's going to continue. And then so as Louisiana pushes back, we continue moving forward. This is the fight that we see on the ground here in Louisiana on multiple fronts.
Mr. Lewis, have there been any lawsuits filed or any legal pushback to all of this stuff?
We have lawsuits everywhere. So one lawsuit is pending right now, whether or not the governor adequately used his executive powers correctly to suspend the election. We've had multiple cases in federal court that have, unfortunately, a temporary restraining order hasn't been taken. In New Orleans, the city council, the district attorney, and the mayor have sued the state and are now pending the Supreme Court. We have candidates who were qualifying, and I failed to say this. So when the governor suspended the election, one of the things that we had did recently is Louisiana historically had operated on what we call the jungle primary. All candidates of all parties run, and in November, if you receive 50% plus 1 vote, you are the winner. And if no one receives 50% plus 1 vote, then the top 2 go to a December runoff. When Jeff Landry came in as governor, he said, you know what? I want party primaries because I want to make sure the Republicans are Republicans. So he passed and issued us now into the partisan primary races for our Senate, congressional, and Supreme Court races. Then when they were worried that Callais was taking too long, the primary was supposed to happen in April. They passed a bill to move the primary from April to May. And then now after Callais, just on Wednesday, they added a new provision into a bill that now for U.S. Congress eliminates the partisan primaries and moves us back to the jungle primary, where now we will vote for our member of Congress in November with the December runoff. So it is mass confusion and chaos down here and lawsuits everywhere.
I can only imagine all of these changes affecting even when people's idea of when they have to vote.
That's correct. I mean, it's not even the fact that these changes are happening. And unlike some of the other southern states, they made these changes while people were casting ballots. 42,000 ballots were already returned to the Secretary of State before the governor issued an executive order to suspend that election. So you are hearing people say, is the entire election suspended? Do I go to vote tomorrow on Saturday? Does my vote count if I voted early? Does my vote count? And so we are, it's mass confusion, and changing now the new process for election in the middle of it makes it even more difficult for us down here.
Is this unheard of? I mean, has this happened before? Maybe many years ago. I don't know.
The
Like in
only time I know we've ever suspended an election is during hurricane season, and we've pushed it back. 2008 was an example
Right.
where we pushed it back, but we have never suspended an election, changed the rules of the election, and basically said, "Oh, we're going to requalify candidates." So they've said, "Oh, we're going to refund all the candidates their qualifying fee. We're going to redraw the lines and then hold a new election." That's just unprecedented, unheard of, and is a dangerous set if it's not corrected.
We'll now hear from Jerome Dees of the Southern Poverty Law Center, who will help us understand the implications in Alabama and the broader trajectory of voting rights litigation. Mr. Dees.
Good afternoon, everyone. I'll be brief because I know we have limited time, and I want to make space for Ms. Wagner and what she's got to provide to the rest of the group. Really just kind of hone in on Alabama specifically and what we're looking at. Both Mitchell and Amir did a good job of kind of laying the historical context of sort of what brought us to the moment. And I think the thing that I would highlight is a phrase that we're all familiar with, that those who don't learn from their history are doomed to repeat it. And we are presently in a moment of a second post-Reconstruction era. I'll provide a little more context for folks. During the first Reconstruction era in Alabama from 1871 until 1877, the state of Alabama saw its first elected Black Congress people from that state in successive elections from 1872, 74, and 76. In 1877, Reconstruction ended, and we began sort of that transitory period that Amir referenced into what we now know as Jim Crow. It would take another 115 years for the state of Alabama to see a Black congressperson, an individual who was the candidate of Black Alabama voters choosing, sit in a seat in D.C., speaking to the issues that matter to the 27% of the state's population who are Black. We find ourselves with the result of the Shelby versus Holder decision, which came from the state of Alabama in 2013, with the ongoing litigation of Allen versus Milligan, which comes from the state of Alabama, at a position where we could be going back to that period post 1870s, where we end up with no Black representation in states like Alabama, in states like Louisiana, as we are seeing in Tennessee. What is important from the sort of legal perspective for Alabama is that there is, at least on paper, a distinction between the Milligan and the Callais cases. In the Milligan case, and I believe Mitchell touched on this earlier, is that in the Milligan case, there is not just the Section 2 discriminatory impact finding, there is also a 14th Amendment equal protection discriminatory intent violation finding by the courts. And so that 14th Amendment claim, even though Callais came down, still should be a viable legal argument. Now, what we have seen from the Supreme Court over this past weekend in their sort of emergency ruling, sending the case back down to the three-judge district court panel, that is still a point that is of contention. And so actually today, the plaintiffs in the Milligan case have deadlines for filing their motions to kind of reaffirm with the district court that that 14th Amendment claim should still lead to an injunction on the maps that the state of Alabama is trying to go back to. On Monday, May 8th, is the state's deadline to respond to those filings. Now, obviously, the very next day, just hours later, is the Tuesday, May 19th primaries in the state of Alabama. And so the implications of that are there is mass confusion and and disinformation that is going on right now. If you scroll your timelines on whether it's Facebook or Instagram or TikTok, there are well-meaning people who are trying to make sure that folks go out to vote and updating people on what's going on and encouraging folks to show up on August 11th, but telling folks in South Alabama in the Black Belt that they don't need to necessarily worry about the May 19th primary election. That could not be further from the truth. What needs to be disseminated to every voter that is registered and eligible in the state of Alabama is that you show up at your polling location at 7 o'clock when they open and vote from the top of the ballot all the way down to the bottom. And then if the courts shake out however it is that ultimately shakes out, there is a need to come back on August 11th, then those affected districts, District 1, 2, 6, and 7 at the congressional level, then you come back and vote again on August 11th. But right now, what needs to be uplifted for folks is that people need to show up and turn out at the polls on Tuesday, May 19th.
All right.
I
Thank
will
you.
pause there and either pass over to Ms. Wagner
Yeah.
or remain for
Yeah, I will do that, and then if we have time left over, we'll answer some more questions. Thank you, Mr. Dees.
We'll go ahead
Yes.
to Ms. Wagner
Go
because
ahead.
I know she's going to uplift Saturday's events as Amir did.
Sarain Wagner, please go ahead from Alabama Values.
Hi, everybody. I just want to ground us in what's happening in Alabama right now because it's bigger than lines on a map. This is about power, this is about representation, and this is about whether Black communities and other communities of color will have a meaningful voice in our democracy. What's happening in Alabama and across the South in general, this is not it. You cannot separate it from this country's history. Jim Crow, they were poll taxes, literacy tests, white primaries used as tools to dismantle Black political power after Reconstruction. It's showing up now in this race-neutral, colorblind lens in this modern iteration with the same discriminatory outcomes. The goal remains to limit the political power and representation of Black communities, and frameworks that claim to be colorblind only make that harder to confront because when the law ignores structural racism and white supremacy and how race actually shapes power, it becomes much harder to prove discrimination or fix it. So what we're seeing now is that continuation of that effort. Example being the runoff system implemented in Georgia. It was implemented intentionally to lock out Black voters in the state of Georgia. And in Alabama, leaders are still manipulating district lines to preserve power and weaken the voices of Black communities. Obviously, that's a real contradiction. A lot of these folks are do as I say, not as I do type of individuals. On the one hand, the Supreme Court in Allen v. Milligan affirmed Section 2 and maps diluting Black voting strength, likely violating the law. On the other hand, doctrines like the Purcell Doctrine have been used to justify keeping those same harmful maps in place during elections, forcing voters to cast ballots under systems courts later find unlawful. Just as a brief reminder, the Purcell Doctrine is supposed to be a law that discourages rule changes this close to an election. It's supposed to serve as a shield for gerrymandering, but that is not how it is being used in the scenarios we're seeing across the South. So, in terms of how voters are responding and processing, like Jerome said, the practical impact is widespread instability. As he said, Kay Ivey, the governor, called for a special primary on August 11th, leading folks to believe that the one in May 19th was not happening, etc., causing significant confusion regarding shifting timelines and new district boundaries. So what is happening for us? How are we responding? So Alabama Forward and our state election protection groups across the state have been working diligently and aggressively to combat misinformation and voter confusion. We also have to think about this from a communications and a narrative framework. A lot of the work we do is rooted in culture and history and meaning making. A lot of these folks have personal connections to what's happening. The folks at the hearings in Louisiana were up till 4 a.m. fighting for fair maps. So this is very personal for many of us. I personally am from Memphis, Tennessee, and was very disappointed and quite frankly angry at what happened to my hometown. And I feel the same way around what's happening in the South overall. So Alabama Values and the Solve Network, we launched the Fight for Fair Maps Continues Working Group, Toolkit, and Resource Hub, which I will drop in the chat for you all to share, with messaging guidance, public education resources, digital assets, and state-specific updates to help our communities make sense of this moment and take action. We also encourage folks to visit our hub, the www.fightforfairmapscontinues.org. Use the resources and share them with their communities. And ahead of national groups arriving in Alabama this weekend, we want to emphasize that local Black-led organizations and Alabama's civic infrastructure have been carrying this work long before national attention arrived, and will continue to long after they leave. This is not a parachute moment. I want to remind folks on the call. This is generational organizing rooted in resistance to white supremacy and anti-Black voter suppression. That is why Alabama Forward and Alabama Values released our joint statement calling for deeper reflection, investment in long-term Southern infrastructure beyond midterm election cycles, local leadership and year-round movement building these transformational relationships and not being transactional. If you'd like to read our open letter, please visit www.alvalues.org/standwithal. Why this matters beyond Alabama? I think it's important to say clearly this fight is not just about us and those of us in Alabama. Alabama is often the testing ground for many things. And so what happens here has implications for voting rights fights happen across the South. And so goes the South, so goes the rest of the country. And we're seeing that in real time. Illinois has had its first attack on its state Voting Rights Act that it implemented. So we're going to see some escalations. But I want to remind people that our folks are not deterred or not, we're angry, but that's not leading us to quit and not be involved in our communities and fighting back. So I'll leave you all with that. If you have questions, feel free to ask them.
Was the ostensible goal of the Supreme Court when it made its colorblind decision to change the Voting Rights Act?
It's an all-out assault on Black political power, but ultimately that attack also means Latinos, Asian American Pacific Islander. It's not going to just end with us, right? You're seeing a lot of the news around anti-DEI. This is all part of what you've heard of as Project 2025. John Roberts has been at this for 40 years, since the 80s, right? This was his passion project to neutralize the Voting Rights Act. So I think one of the things we can do, we really need to think through term limits for the Supreme Court. We've expanded the Supreme Court 7 times, so it's not like we haven't done it before. And maybe think through what unity coalition maps look like now that I don't know, Mitchell, you might want to chime in on this. Maybe we can do it now and really build up, because we have power in numbers. But I will say it's really about the way in which you target Black people is through birthright citizenship and the Voting Rights Act. And the birthright citizenship case is going to be decided this term.
And the one thing I'll add, Pilar, is that they want to go away from racial classifications because they want to ignore history. The racism has undergirded this country since its founding. There were slaves at its founding. Women and Native Americans and Black people could not vote when the Constitution of this country was written. So they want to ignore that. And so until we deal with the root of racism and discrimination and the effects of said racism and discrimination, we're going to continue to have these problems, and the courts just want to ignore it right now.
Can I just say one more thing?
Of course.
Again, we need to tie this back to history. This is the exact same move that was made in the late 1800s after Reconstruction, where the 14th and 15th Amendments said you cannot discriminate on the basis of race. And so states in the South said, well, maybe we just won't say where we want to discriminate against Black people. We won't say that we're intentionally discriminating, but that will be the effect of what we do. And so that's why they passed these colorblind, race-neutral things like poll taxes and literacy tests. That's the exact same move that Alito and the 6-3 majority in Calais is making, because they're saying that the 15th Amendment only prohibits intentional discrimination, just like they said in the late 1800s. And so I just want to make that parallel very clear to folks. It is the exact same thing that is happening right now.
Okay, thank you. Another question from Rebecca Bartus. How can voting rights organizations mobilize voters in this climate when many feel as though their vote holds less power in these gerrymandered districts?
I can start. I mean, here in Louisiana, I think when people realize or feel their vote is under attack, it seems to mobilize. We don't have much on our ballots for tomorrow, but I'll tell you what we Black voters since Calais came. Typically, for an election around this time in Louisiana, Black voters make up somewhere between 22 to 25% of the early vote. When early vote ended last Saturday, Black voters made up 36% of all ballots cast. Just yesterday, looking at the remaining ballots that were coming in from absentee ballots, or vote by mail for our seniors and military individuals, Black voters typically only make up around 22% of those ballots that returned before Election Day. As of last night, Black voters were 37% of all the ballots that have been returned since last Saturday up until yesterday. And so what I think that shows is that even in this moment where our vote is under attack, people are recognizing the moment and the movement, and they're saying, you didn't take my vote away. You may have tried to take my representation away, but my vote is still here. And so I think that's a powerful organizing model to just say, people, show up and vote, because the one thing that I think starts to scare them is when the mobilization happens, when the organizing happens, because they are so used to seeing low apathy, low voter turnout. And here, at least in Louisiana, we are organizing voters to say, this is your moment to say, I care about my vote, and my vote still matters, regardless of how you try to draw me out and deny my representation.
Just briefly add to that is, I think the one thing that often gets overlooked is the history of Black Southern resilience to efforts like that. That we as a people, as a community, have been through this before, as has been detailed over the past hour, and we as a people know how to respond to empower and uplift our fellow community members. And so I think what we have already seen by early voting numbers in Louisiana, in demonstrations and collective calls to action in Alabama and throughout the South, is that there is a real desire to mobilize and strategize and build a new sense of community as we move forward.
Also, we're 52% of the population, Black people. A lot of us did not leave during the Great Migration up north. And so there's power in numbers. And I'm seeing the same thing Jerome is and Amir. Like, you've pissed us off, right? You've unleashed the entirety of our ancestors' rage, our rage. Like, I don't think these folks realize what they've done. And also, I think it's important to get out into community and talk to people about what this means for them. And it's never too early to prepare for the next census, right? And fight for 2030. We're 5 years away from the next census. And I think it's critically important. We really need to start having those conversations now.
Yeah, and there's a question in the chat by Sandra Martinez, who says, she's from Peninsula 360, as members of other minority communities, let's say Latinos, Asians, and others, how can we support or advocate for this situation, for this issue?
I mean, I think it starts with understanding that this is all intersectional, that we are all in this together, that when those in power come for one, if they haven't come for you yet, they will be coming shortly. And so while those direct attacks may be focused on the Southern Black community right now, that does not mean that they will not be coming for Southern Latinos, that they won't be coming for labor, that they won't, I mean, they've already come for women's bodily autonomy. And so understanding that all of these issues are interconnected and deal with the power of the people to sort of express their choice and build the lives that they seek for themselves. So I can guarantee you that there is some type of organization in your community that you can be a part of, and I can promise you that that organization is finding unique and organic ways to get plugged into their community. And so I would say tap into the things that make you passionate, that move you, and engage in that organic and authentic sense.